Live on YouTube. You can begin the meeting, gentlemen and ladies.
Okay. Bang the gavel. This is the August 28th, 2020 meeting. of
No, it's quality beef.
Okay,
All right, I'll be next to my phone.
okay. Let's start again. This meeting is called to order on August 28th, 2020. It's the meeting of the West Warwick Zoning Board at 7:04 PM on August 28th. Rachel, go ahead and with the roll call, okay?
Kelsey,
Present.
Alan Hort,
Here.
Justin Kutu,
Yeah.
Richard Banks,
Richard, you're muted.
Here.
Michael McPhillips,
Here.
Amy Ortiz.
Quorum's present.
We have a quorum on record. Okay. Next item on the agenda is the approval of the minutes of June 24th, 2020. Are there any either corrections or commentaries or anything to be changed?
Mr. Chairman, there is, unfortunately.
Okay. Why does that
On,
not shock me?
Well, it's kind of odd, but housekeeping, the roll call votes on numbers 3 and 4 are somewhat incorrect. There were 6 people voting on the first two, and the first three votes have 6 people voting. I was eliminated on the first vote.
Well, that shouldn't be. You're a voting
And
member.
I voted a yes, but on the next two, there are 6 people that are listed as voting with all yeses.
Okay. Yeah, that should only be 5.
Yeah.
That should probably be changed to the 5 voting members, if we can do that in a housekeeping situation.
Yep, I would agree with that.
You can change that, right, Rachel?
I'm sorry, Peter, can you repeat that?
The petition for Villanova Realty, when the vote was taken to close the public hearing, my name was left off with a yes vote, and I believe Amy Ortiz was included in the yes vote. On the next 2 votes, one to approve the hot box, there were 6 people's names listed with 6 votes. I believe Amy Ortiz's name needs to be removed there. And on the motion by Justin Kutu, motion for Doug McLean as a professional planner, seconded by Alan Hort. There's 6 people's name on there. And I believe, again, Amy Ortiz needs to be taken off.
Yep, that's right. The 5 voting members should be
Yeah. I
on
vote
that,
no.
basically
I'll have that
amended.
fixed for you, amended.
Thank you.
Absolutely.
Thank you. At this time now, generally, Pete, is that it? Is that all you got?
Yeah.
You gotta take a motion to approve as amended.
Let's make a motion.
Approve as amended.
I'll second it. All in favor?
Aye.
Aye.
The ayes have it. Okay. Generally, what we do now is we go to the next petition, which would be the petition number 2019-13, but we're gonna change that. We're gonna have 2020-6. Go, you can make the motion, Peter, go ahead.
All right, I move that the board accept the change in the agenda with petition number 2020-6, applicant Tyler Leonard, owner Synergy Capital, to a first position to be considered by the zoning board.
Got a second?
I'll second.
Okay.
At this time, I would like to recuse myself from this portion of the hearing.
Okay, thank you, Rick.
Thank you.
On that situation, all in favor?
Aye.
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 The ayes have it. We have 4 ayes on that. We have 4 yeses on that one. not the normal 5. We have 4 on that one. Rachel, okay?
I'll go over it with Rachel.
Okay,
Mr. Chairman,
yep,
I received a communication from attorney Joseph Brennan a couple of days ago. He had just been retained by the applicant. We discussed it because there was some unusual background, as you're aware from my report. Mr. Brennan requested a continuance because he had not had the opportunity to get into the details of this matter. And I told him that I would request that the board continue the matter to 7 o'clock, September 30th, at a hearing of the West Warwick Zoning Board of Review to be held in the West Warwick Town Hall or via Zoom webinar. I would request that the board make such a motion and approve the continuance.
I'll make a motion to continue that matter to September 30th at 7 o'clock.
I'll second.
Okay.
I vote all in favor? Aye,
Aye.
Aye.
okay.
Thank
So the
you.
ayes have it on that one also.
Thank you.
You're welcome. Okay. So now we're gonna do the petition number 2019-13, Mr. Al?
Yes.
Okay. The next petition on the agenda is petition 2019-13. The applicant Equality Realty LLC, which has been continued more than once. Premises 40 Keys Way, plat lot 30, lot 51, zone is BP. The proposed use, the applicant is seeking a special use variance for warehouse, general, and refrigerated food processing and kindred manufacturing, processing or packaging under section non-resident use regulation LI, food and kindred manufacturing, processing or packaging, and K6, warehousing, general, and or refrigerated of the zoning ordinance of the town of West Warwick as amended. Now, generally, on this situation, we would have testimony, but we've already had testimony on this, and we've basically closed it down to a situation where if there are any stipulations from any of the board members, I guess this is just a situation where the board members will be speaking to each other. If there are any stipulations that they would like to have put forward, we can hear them at the present time.
Mr. Chairman, on this matter, the public hearing has been closed.
Yep.
This matter, there has to be a motion to approve the application, discussion on the motion with any possible stipulations, and then a vote on it. And that is the extent of the hearing on this matter.
Okay. Anybody want to make a motion?
Mr. Chairman, I'll move that we move the application for discussion.
Any second?
I'll second.
Okay. All right, let's go right well to the discussion. Do we have anybody? I mean,
Who seconded?
I want, what's that?
Who seconded?
Me.
Justin did.
Okay.
Let me just put it this way. Does anybody have any stipulations that might be of concern besides Mr. Kelsey?
I have none, Mike.
How about you,
No,
Justin?
aye.
I have none.
You got none?
haven't.
Okay, I really have none either. So Pete, you have the floor.
Well, I had conversation with our solicitor.
Okay,
And I sent him some suggestions. I'm not sure if Al had an opportunity to bring those to the parties involved, both the applicant and the abutting property owner, the hotel.
Yep.
What my concern, my main concern was having something in hand with the application not going to the planning board where the stipulations might have been drawn or negotiated at that time. I felt it obligated with some concerns that we heard from the legal counsel from the hotel that we put in stipulation specifically regarding the border of the property with a possible berm or area of a 4-foot wide mulch border and including 5-foot-high arborvitaes placed approximately 4 feet apart from one another along the L-shaped border between the two properties. That was my main concern. I don't know if there's any others that a solicitor may have discussed specifically with the lawyer from the hotel. I know that we cannot make specifics regarding future build-outs. That if something comes before the board, or if something, the applicant or the owner of the company, either now or later, decides to put an addition to the building, that they would probably be coming to either planning and or zoning both at that time.
Yeah, if they don't meet all the stipulations and the setbacks, yeah, they definitely would have to, if they
Yeah.
don't.
Yeah. What we saw in the plan was in speculation, so it's not something that we can respond to. I did mention briefly, if because of the large amount of parking spaces on the applicant's side, I'm not sure if they would have agreed to do away with there's about 6 or 7 parking spaces on the east side of the building facing the hotel.
I believe that those spaces are allocated for the office employees only.
Right. I appreciate that. I can understand that. Yeah. Those are my concerns. The significant one, I believe, some of the things that we talked about, I believe was assured at our last meeting regarding a possible sound retard for the backup. The backup
Of the trucks.
operation of the trucks.
Of the
Yeah.
trucks, yep.
I think that might have been something that could be put into speculation, stipulation rather.
Which I think the gentleman said that they could do that, right?
Yeah.
He did agree to that.
The business owner said that he could do that, right?
Yeah.
Wouldn't be a big burden for him.
I'll ask our solicitor, should it be added as a stipulation at this time? Al?
As far as the, I think the record shows that they had agreed to the sound trucks.
Yeah.
I personally think that if it went forward with the plans as submitted, it would satisfy the needs, because I think the goal was to keep the noise on the opposite side of the building. I believe there was information that the building was of a very large size, so that was going to act as a sound barrier to begin with. How much more you can do than that, I don't know. As far as the addition to the building, if the building is going to meet with town standards, they have the right to do that, to enlarge the building. If they were going to change the use or require setbacks, then they would have to come before the board. So that just to say, if you want to put an addition on your building, you have to come back to us. I don't think that's proper.
I agree. Do we put a stipulation in for the backup operation, Al?
What do you mean by the backup operation?
But
He means by the
The
beeping
trucks,
of the trucks when they
the
reverse.
noise of the trucks. I think,
Oh, yeah, I think you can put that stipulation in.
those would be the two stipulations that I would suggest.
so,
Which one of the two?
so Pete, the initial one would be the berm with the arborvitaes.
Correct.
Is that kind of, in a nutshell, the first one?
No, that's it. Yeah.
Okay, and basically the second one would be the backing up of the vehicles. I mean, I think, like I say, I don't want to belabor a point, but I think the gentleman last time.
I'm
he
not
was
sure
on to
what,
the- do
I'm
that.
not sure what you're saying, to put this into a stipulation. I'm not sure exactly what you're meaning by the backup,
That's the backup noise. Beep, 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 beep,
Yeah.
beep, beep.
oh, okay,
Yeah,
okay.
lower the backup noise of the truck that's backing up, because those
Yeah.
big, the 18-wheelers, they definitely do make noise. There's
Didn't
no
he call
doubt.
it like an alarm silencer or something?
Well,
Say
you gotta
again,
be
Justin?
careful with it. You gotta be careful with it because there's liability along with it too.
Also, I don't know about that. I'm gonna guess there's probably some federal regulation out there that says they can't do that.
Well, that's what I said. And there's probably
Yes.
liability for it.
That one Peter might not be able to get. That stipulation might not be able to get that one. I mean,
My suggestion, Peter,
the
would
other,
be that
the
Do we have
other-
the owner here? We have the owner speak to that, or the
no,
testimony is closed, right?
closed.
yes,
My,
yes,
my
that's the one close.
suggestion, Peter, would be to reduce backup noise as long as it complies with all
Federal
state and
regulations.
federal rules and regulations.
Perfect.
And the other stipulation is with the berm and the arborvitae's.
Yeah.
Arborvitae's 5 foot high, 4 feet
Okay.
apart.
But don't they grow like forever arborvitae's if you don't cut them?
At least 6 inches a year, certainly.
Okay. And that you'd want on the side in between the,
L
where
shape.
kind of in between where the properties are.
Right, but it forms the L shape. It's on the east side of the building, and then their property goes off closer to the hotel.
Okay. Well, basically you
everyone
separated the
following?
hotel from the building. You're not going to put it where the trees are, where the bow wow is. You're not going to put it on that side. You're going to put it on
No,
the side.
no,
You're going
no,
to put
no.
it on the side where the hotel is.
But their property is L shaped. Their property is L shaped. So I'm asking for the berm to be on where the two properties abut, which is an L shape, facing east, and then part of it is facing north.
Pete, you got me when you face east and face north. You gotta going back to where the trees are and you hang a right.
Like between the two buildings.
Thank you.
Between the two buildings.
We need Rhode Island directions here.
Yes, we need Rhode Island directions. Okay, Pete, where the old Almac used to be. You can do directions by that way.
You need a motion, you need a motion to amend the prior motion and add those two stipulations.
I
Okay.
want to say that again.
Could I just clarify, are we taking the stipulations one at a time, or are they going to be bundled together for a vote?
One at a
Why
time.
don't we-
All right,
Yeah, let's do one at a time.
So motion to amend stipulated with the arborvitae amendment.
Okay.
Mr. Chairman, I move that the zoning board of West Warwick makes the stipulation for a 4-foot wide landscape berm to include arborvitae trees / bushes, 5 feet high, 4 feet apart, along both sides of the properties, bordering both properties between the buildings, the building of the applicant and the building of the hotel.
and Peter, can I just ask a clarifying question? The purpose behind that stipulation is mainly noise abatement?
Noise abatement, and also the arborvitae's will in fact grow, and some aesthetics,
Aesthetics?
aesthetics, so that we're not just looking at a blank wall back there.
It's like a fence without a fence. Kind of, sort of.
Exactly.
Kind of a fence without a fence.
For the eye, for the
For
aesthetics
the,
of the,
for the aesthetics, yes. We have a second on that?
Second.
Was this a roll call? Is this a vote? Al, is this a roll call? Or is this just a
Roll call.
roll call?
Yes.
Okay, Rachel, you're up.
She's muted.
Yeah, maybe she's having dinner.
Oh, she's on mute.
Tough for us to
Already
hear.
had dinner.
Okay,
All
good.
right. Sorry.
It's okay.
Peter Kelsey,
Yes.
Alan Horak,
No. My feeling is that the owners have done enough as far as noise abatement goes. And I would hate to have us add additional burdens to them.
Justin Kutu,
I'm gonna go with no and agree with Alan on that one.
Banks,
I will also be voting no. I feel that the applicant has done all their due diligence and everything in their power to ensure that they're meeting all these requirements. So I'll be voting no.
Mike,
Yeah, I'd vote yes. I kind of agree with that. I think it's a good idea, but that is going to be, the motion is denied 3-2. Right,
yes.
Al? Motion is denied 3-2.
The motion to add the stipulation,
The motion
is
to add the
denied.
stipulation is denied. Okay, Pete, do you want to come back with the second one? The second stipulation?
I'll let whoever recommended that at the last meeting to do that.
Okay, I'm not sure who that was.
I'm not either.
Neither am I.
I don't know who that was, to tell you the truth.
I think I'll try and capture what Al stated as far as we'd stipulate backup alarms, backup alarm silencing system on the delivery vehicles, as long as they are in compliance with all federal and state
Regulations.
transportation regulations.
I'll second that
A
one.
second.
Any discussion? We want to go to right to a roll call? Is that okay? I'll write to a roll call.
yes.
all right.
Rachel, you're up again.
Okay, I was making sure I wasn't muted. Sorry. Peter Kelsey,
Yes.
all right. Alan Horak,
Yes.
Justin Kutu,
Yes.
Richard Banks,
Yes.
Michael McPhillips,
Yes. The motion on the stipulation to have the backup noise for the trucks passes as long as it meets state and federal regulations. Was that said right, Al?
Yes, and at this point in time, the board now will discuss and then vote on the motion to approve as amended.
Okay. Want to make a motion?
Motion to move as amended,
Motion to a move as amended.
a motion to approve
Approve.
Motion to approve
as amended.
as amended.
I'll second.
Okay. All in favor?
Aye.
Aye.
The ayes have it. Okay, now we are at the part where we are going to the okay or not okay of the original application, right, Al?
Right, you're gonna discuss it and then vote on it.
Okay. Now, generally, Alan, this is where you come in. This is where you usually read off stuff. If you want to, if you don't want to, I'll take it. I'll take over.
No, I'll take a shot at it. So this
Okay.
is make a motion to approve petition 2019-13, the applicant Quality Realty LLC, Keys Partner LLC, granting a special use permit for where they want to construct a building for warehousing general and refrigerated food and kindred manufacturing, processing and packaging. And as amended. by the prior stipulations.
To include the 3 or 4 items on there.
For the special use.
Specific permits for special use.
Yeah.
Use is compatible with the neighborhood.
Well, this is just the motion, Peter.
I understand.
That come in your discussion.
Okay. All in favor of the motion?
You need a second.
I'll second.
Second.
Thanks, Justin. All in favor?
Aye.
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 Okay. Now we can discuss, guys. What do you think? I think my opinion is it's a great idea. I mean, Pete, when you were councilman, I'm sure you would have thought it's a great idea to have a company to go in there that's going to employ 100 people.
Absolutely.
I mean, this is what this town needs. This is what this town wants. It wants people that are going to put to work.
And I'll make a little bet with somebody.
No, I don't know about that. We're on candid camera. I wouldn't do that.
And who it's with and what it's for.
Don't do that. I mean, in my estimation.
I bet we might see some abreviate trees anyway.
Okay. Well, that's for another day. You know something, I'll kind of go first. I don't generally do this, but I'll probably go first on this one. I would say that I'm definitely going to be voting yes. It's definitely compatible with the neighboring land uses. It's a business park. You want businesses in there. Well, people are going to employ 40, 50, 80, 100 people, maybe 200. Right? It's not going to create a nuisance in the neighborhood. It's not in a neighborhood. Right? It's not going to hinder the future development of the town. It's in a business park. And it does conform to all applicable sections of the zoning ordinance. And it's definitely in purpose, intent of the comprehensive plan. So I will definitely be voting yes.
Okay.
I will be doing the same for all of the same reasons.
I'll also agree with that.
Yes, I pretty much agree with everything Michael said, and we'll be supporting this.
And I will be voting yes as well for all of the same reasons.
I think we're pretty much in unanimous agreement. Rachel, why don't you do the vote, okay?
Peter Kelsey,
Yes.
Alan Hort,
Yes.
Justin Kutu,
Yes.
Richard Banks,
Yes.
Michael McPhillips.
Yes. The motion passes. Finally, okay.
I know Attorney O'Connor's here. I don't know whether Attorney Landry's here or not. I will be getting the orders prepared and out and once signed, they'll be sent to you.
Okay.
Thank you
Okay,
very much.
I
Okay.
believe we need to make a motion to adjourn this
No,
meeting.
yeah.
No?
Yeah,
Yeah.
Motion
yes,
to adjourn.
I'll second.
This meeting is now adjourned on the
you're adjourned.
on the zoning board of review.
And
Okay.
now you're gonna
I'll
call
open up
a
the
meeting.
meeting as a zoning board of review, sitting as the Board of Appeals.
Yes,
We have many hats tonight, guys. Okay. We have to make a motion for this, Al, or is this,
no, you opened up the meeting
okay,
platform.
okay. Is the host here? Is
Chris
he on?
Tyler, are you here? John,
I'm here.
Is Mr. Tyler anywhere in,
I see a lot of phone numbers or
okay,
a call-in user, but nobody by that name of Chris Tyler, just phone numbers. So let me do something real quick here, guys, so I can give them some instructions
okay.
so they can raise their hand. Just Google it real quick.
John,
Yeah, I'm here. I just want to make sure they know how to raise their hand.
once they do and you put them on, I
I'll-
have to
Okay.
get their name, address, and swear them in.
Yeah, exactly. Okay.
Al, do I have to, Al, quick question for you on where it says section 1744 appeal standards of reviews. Do I have to read that or do we just have to go by that?
No, that's just what you go by.
Okay, okay.
You just read. his
What we have on the
application.
agenda.
You just read what's on the agenda.
Okay, thank you.
If somebody wants to raise their hand to speak on their phone, if they're on a phone call, I should say, not using a Zoom app, but if you're on a phone call and you called in and I see a phone number, you hit the *9 on your keypad and that'll raise your hand and I will let the board know you want to speak. So *9 on your phone. Somebody did raise their hand. I will allow them to speak and Al, you can go to it.
Okay.
Why don't we do the petition first and then the person can
Yeah,
raise their
all
hand?
Okay.
How about we do that? Okay.
Yeah.
Okay, the petition number is 2020-5. The applicant is Christopher Tyler. The owner applicant is June M. Carter and Shoreline Properties, with the premises being 146 Cohasset Avenue, plat 13, lot 599. The applicant, Mr. Tyler, is appealing the February 3rd, 2020 decision of the West Warwick Planning Board, removing the stipulation requiring the developer to apply to RIDOT for access to the proposed development from Cohasset Ave under section 17-31 Board of Appeal and 17-41 of the West Warwick Land Development and Subdivision Review Regulations. Okay, at this point in time, Al, I have a question for you. Do we now let Mr. Tyler have the floor, or do we have the floor first?
No, Mr. Tyler presents his case, then any people who want to speak, either on his side or opposed to him, have the right to speak. I would not worry about getting all affirmative and then all negative. Just let the people speak.
Okay,
Al,
Yes.
before we start, I have one item, I believe that needs some clarification or correction. I believe there's a word that doesn't belong in that petition that Mike just read. The owner, June M. Carr and Shoreline Properties. To my knowledge or my understanding,
They're not
She-
applicants.
he is not an applicant.
No, they're just the owner.
Right, so
This is a matter that,
I just want it to be put into the record
right,
that she is not an applicant as was read. Yeah,
just for the purposes of the record, the point that Peter makes is that the June Carr was an original applicant. Was an original owner. The applicant was Shoreline Properties. They went before the planning board. Shoreline Properties to develop a project on the June Carr property. So I might as well fill in the whole record. The planning board initially said that in approving the master plan, they ordered Shoreline Properties to seek permission from Rhode Island DOT to have an access to the property onto Cohasset Avenue. Subsequent to that decision being rendered, the Shoreline Properties filed a motion with the planning board requesting that stipulation be removed. And the reason behind it was that they alleged that the piece of property through which the access was going to be made was owned by June Carr and was not going to be sold as part of the development. So they could not, they said there's no sense in going to DOT because we don't have any rights through that property. The planning board heard the matter. They then recessed and requested some type of documentation that the June Carr had no intention of selling that particular lot. That evidence was submitted by way of an affidavit
signed by June Carr, the planning board in its discretion determined that that affidavit was sufficient to accept the representation that the shoreline could not get access to Cohasset Avenue. So there was no sense in making them go to the DOT and request approval. They then removed that stipulation from the decision granting master plan approval. At that point in time, Mr. Tyler filed an appeal from the decision of the planning board, removing that stipulation. The matter is here tonight on behalf of Mr. Tyler in his request to overturn the decision of the planning board, removing that stipulation. I will caution the board that it is a two-step process for the board in listening to the facts. The board must determine what facts that are alleged are discretionary actions of the planning board and what facts are alleged that are factual facts. Anything that the board says is a discretionary matter of the planning board. The zoning board has no authority to substitute its judgment for the judgment of the planning board. To give you a brief example, so we can set this record straight as the hearing begins. If a matter came before the board where the planning board had set an engineering fee in setting a bond, and somebody appealed that the amount of the engineering fee. Engineering fees are totally discretionary. I may think they're low, you may think they're high. It's totally discretionary. In a situation of that nature, the zoning board has no authority to overturn the planning board. I spell that out so that the people here by phone and the zoning board know what this process is that they are about to undertake. Okay, John.
All right, so there's a gentleman who wants to speak. He can hit *6 to unmute himself. There he is. Okay, Alex, he's unmuted.
Yeah. Could you state your name
Am I
and
here?
address, please? Yes.
Christopher Tyler, 31 Carlson Circle.
Hold on, Chris. I assume you're raising your right hand. Did you swear
Yes,
to
I
tell the
am.
truth, the whole truth, and nothing but the truth?
I do.
Thank you. What was your address, Chris?
31 Carlson Circle,
Okay,
West Warwick.
go ahead.
All right. My biggest thing with this whole thing and with my entire neighborhood is that the meeting on February 3rd, where the attorney agreed to get this information. Now, the problem I have with this, if he agreed to get this, instead of saying from the very beginning that Mrs. Carr had no intentions of either moving or anything like that, that should have been said at the meeting. But I think that at the meeting, the plan was her property was part of this. And 4 months later, we come back with an affidavit saying, no, she's staying, and that's that. And I had neighbors there. We all showed up, and nobody was able to say anything about this. They agreed on the February meeting to get this information for a reason. And the reason, September, whatever it was, 2019, they agreed to that, to get it, and they never did.
Chris, let me interrupt.
Yes.
And because I was there, let me explain to the board
Okay, no, go ahead.
what you're saying.
Yes.
Put in perspective, what Chris is saying was at the September meeting,
Yes.
when the planning board
requested that stipulation. The
Right.
attorney for the applicant
Yes,
agreed to the stipulation.
right.
It then came back later on after agreeing to it and asked that it be removed. Chris, did I state the facts that you're talking about?
Yes, you are. You're exactly right. And I have a problem with that, and I think everyone else should, because why would you agree to that if the plan was never to have her property involved? Why would you agree to it? And then 4 months later, we come back to February and with an affidavit saying, oh, no, she's gonna stay there. Well, I think there's something that's not right there. And all my neighbors do, and I don't even want to get into this, but 3 weeks ago, I had 40 of my neighbors on my front lawn that I talked to, and I brought them here, and they're all mad because we're not getting answers on this, and something happened here. That September meeting, they agreed to this, and they never did it. They took the easy way out because they want the entrance to go where they want, and they don't care what happens to this neighborhood. They do. And all my neighbors do too. That's my appeal.
Any questions for Chris?
So my question is, were the members of this neighborhood given the opportunity to speak to the planning board in regards
No,
to
they
this?
weren't.
And then,
The meeting in February was about not even 3 minutes long.
Rick, what happened was when the applicant came back in requesting the removal of the stipulation, the members of the public were allowed to speak at that time. That meeting, like your meeting that you just had, the public hearing was closed. And the secondary meeting was for the sole purpose of the affidavit, which there would be no discussion on. So that the members of the public had the opportunity to speak when the request was made. They did not have the opportunity the second time because the public hearing had been closed, and that was strictly for the review of the affidavit, much like in the last hearing, it was strictly for your review of the facts and rendering a decision.
So would it be safe to say that the public had input in the September planning board?
I'm not sure the dates, but it was at the first meeting when the request was made, the public had the right to speak.
so for every subsequent meeting after that, they did not have any.
There was only one.
There was only one and nobody spoke at that one. We weren't allowed to.
Mr. DiFiore, may I interject as the facts are being muddled somewhat? Just for procedural purposes, may I lay out the approval schedule, hearing schedule for this matter?
It would probably be wise.
Okay. So members of the board, Thomas Cronin, I represent the applicant. This matter was on for a public hearing for master plan, September of 2019. That is when the stipulation was included and public comment was allowed after notice. In November of 2019, the error was discovered and a request was made to the planning board to remove the stipulation. They required a public hearing with notice, which was held in January of 2020. As Mr. DiFiore mentioned, after the public had a chance to again make some input, public hearing was closed, and the February 2020 meeting was when the planning board considered the affidavit without public testimony.
All right, Tom, that's a lot to digest. Hold on a second. So let me just get this straight, okay? In September was the initial meeting.
Right, public meeting.
That makes sense, which was like a normal meeting. We have there's the members and there's the people in the audience.
That was the initial
Original
application.
application. Okay, now at that time, that's when at that time, that was when there was gonna be something going to Cohasset Avenue.
In the decision
In the
of the
decision.
planning board from that meeting,
Okay,
the decision had a stipulation that the applicant would would file a request with DOT
yep,
to have access through Cohasset Avenue, which would have been the property in which
which Ms. Carter owns.
Ms. Carter owns.
Okay,
At that hearing, the applicant's attorney, as Mr. Tyler said, agreed to that stipulation.
okay. So now we go to November. So what happened in November now?
November, the applicant files a request with the planning board to eliminate and remove that stipulation on the grounds that it is no longer possible.
So in 2 months, it went from saying, okay, we're gonna go to Cohasset Ave to 2 months later saying, we're not gonna do that. Long
And
and
then
short.
in the hearing on that was held in January. In January, everyone had a right to speak.
When you say everybody had a right to speak, that means people in the audience.
Yes. At the end of that hearing, the public hearing was closed and it was continued for the sole purpose of receiving an affidavit regarding the status of that piece of property. In February, that came about and the board received the affidavit, accepted the affidavit and removed the stipulation. Mr. Tyler is correct in stating that they were not allowed to speak in February. They were allowed to speak in January and they were allowed to speak in September.
I have a
What was
question.
the general consensus in January, Tom? I guess that's a question for Mr. Cronin, I guess. I'm not sure, or Mr. DiFiore, since
No,
member of
Mr.
this
Tyler,
board was-
that's the question for Mr. Tyler.
Well,
Can we go back to September?
sure.
In September, the applicant for the project was June M. Carr and Shoreline Properties. Would that be accurate?
The owner was June M. Carr, the applicant was Shoreline Properties.
Correct, okay. We don't have any of that paperwork in front of us to make notes of or to recognize what was on specifically. Did they present a plat map at that time?
A plan was presented.
Yes,
On that plan, what was the status of Ms. June Carr's property?
It was a lot in this 8-lot subdivision. It is the lot that has her home on it at 146 Cohasset Avenue.
it was included in the subdivision.
I understand that. Was there any preparation, overlay specifically in preparing that plat map regarding a curb opening on Cohasset Avenue in order to make an entrance back in the September presentation of the plat map?
No,
No, that was a decision of the planning board.
Right.
So what Peter is saying is that her house was part of the development.
No, it wasn't.
Yes, it was.
it is.
Okay,
Still is.
that's what I
It was,
understood.
it was part of the development, but not.
Not an access road, but her home was no longer going to be there. It was going to be part of the development.
No, her home will
Her
retain.
home's staying.
Okay, all right, just want to make sure I understood that. I'm sorry.
Well, we're
So
talking
it sounded
back
like
in
it was going to be a new
September.
home
We're talking
of that
back in
development.
September. We're talking back in September.
Yes,
The
Was
original,
the plan to leave her house on the property in September?
yes.
As part of the development,
I understand.
yes.
As I also understand, again, not having that information in front of us, not having specific measurements, I understand that the house within its dimensions now, you could not make an access road with her house still being there. from Queeset Avenue into the plat. There was no square footage or width of a road that could be put in without either moving the house or removing the house. Would that be accurate?
That's correct.
Okay. So going back to the original, excuse me, isn't that what we have now?
The plan has not changed, Mr. Kelsey. Ms. Carr intends to retain her home on Queeset Avenue, and that is a lot in this 8-lot subdivision. The building will remain where it is, and there'll be 7 new lots on the baseball field behind her home.
Right. Okay.
Can I ask
I was
what,
Thank you.
confused.
who or what instigated that request for the access from Cohasset?
There was concern from the neighborhood about the amount of traffic. It was the idea of the neighbors.
Okay.
So Tom, in
And then-
September. Go
Can
ahead.
I ask,
Go ahead.
so just to follow up, so it was instigated at the request of the neighbors. The planning board took that and they did include that initially as a stipulation.
Yes, and I would like to have Mr. Tyler give his statement on that aspect of it.
So Tyler, you're muted. You have to hit *9 to unmute. Or *6, sorry, *6.
Chris? Stop. Chris, have you heard what's going on?
I have been hearing, yes, I'm just trouble with the unmuting part. I'm having trouble with that, but
All right,
yeah,
can
yes,
you,
I have been hearing that.
I'd like you to give your statement at this.
Well, I mean, the statement is the same. I mean, the meeting in September was, the end of the meeting was that they were gonna supply information from the Department of Transportation if the exit could either, now, if the house wasn't gonna be destroyed or moved or anything else, if she wasn't, why would they agree to this? Why would you say, okay, we're gonna get this information, and then come back later and say, no, we're not gonna? There's a reason why, and we all know why. Because it's a pain in the ass getting
I would like to hear the reason. I don't know.
You'd like to hear it?
Yeah.
What?
Yes.
You want to know the reason?
I would like to know what you feel the reason is. I honestly do not know what the reason might be. Other
Why
than,
what? Other than, go ahead.
other than the obvious that there's a second egress to that plat.
Right. Then why was it agreed to get information if the access could be put right into Cohasset Ave? That's where it falls.
And you say they, who was going to do that, sir?
I don't know.
Sunset-
Whoever agreed to, the attorney for Shoreline or whoever, I don't know who the attorney was. I'm not a lawyer. I'm just a neighbor.
I can
understand that. You were there,
I know.
we weren't there, sir, so we're trying to get a little bit better idea.
And well, I'm trying to tell you what happened. I mean, I'm sure it's documented. You can watch it on a video. I've
Peter,
seen
what-
it.
Stay with us, Tyler. What happened was, as it was said, the neighbors requested it. The zoning board.
And the attorney agreed to it. Now,
And the attorney agreed to that stipulation.
Right.
The attorney for Shoreline did agree to that stipulation.
So.
Without knowing if it could be done.
But they agreed to it. And how come we're not sticking to that? All of a sudden now, we come back with an affidavit from Mrs. Carr that she wants to stay there all of a sudden, and we're all supposed to say, okay, that's fine. So take away the stipulations that you agreed on, whoever I'm talking to, and that's it. Well, that's not it. I don't know. I mean, that's it. I don't know what else to say. The entrance shouldn't be going into a neighborhood that can't stand it anyway. And if you even look at this plat, the exit and the entrance should go right to Queeset Ave. That's where it should go.
If that could have been arranged, absolutely, 100% agree.
Yes. It should have, you know, it was agreed to get that information from the Department of, that's my problem with this. It's very easy to come back 4 months later and say, no, we can't get it because Mr. Scar's going to stay there. So now that makes it all okay. Well, that should have been said in the September meeting, and that shouldn't have been agreed to.
Mr. Tyler, and this is.
Yes, sir.
This is Peter Kelsey talking.
Right. Right.
I agree where you are.
Yes.
What I've heard in the last, and you know, not gossip, but what I've heard from members of the community, some that live in that area, that I understand, Miss Carr changed her mind.
She changed her mind. Well, that's pretty easy to do.
Well, let me tell you, when my mother-in-law was ready to leave her house,
Yeah.
how she passed away, she changed her mind 4 times. She
Well,
changed her mind 4 times in a 5.5 year
yeah.
period.
You know,
Not
a change
selling
of her mind is going to change my neighborhood. And I don't think that's right. Neither do my neighbors. You know,
Well,
that's.
There's a beautiful area back there.
Yeah. Yeah.
And it comes down to, maybe you should make an offer to Shoreline Property to do something different.
Yeah, if they're going to do it, then do it right. Don't just slap it up and then destroy this neighborhood and walk away.
Yeah, I agree with that.
Yeah. This road cannot stand any more cars. I know, I've been here 20 years. And you think it was some kind of a blessing being by the field. The field is nice, but kids party in it. They do this and they do that. But this can't handle any more traffic.
Mr.
The
Chairman,
entrance needs to be, if you want to build, the entrance needs to be off Queeset Ave. I mean, you can look at this plan and even just say, the common sense thing is, put the entrance to the closest main road, not make people drive through a neighborhood to get to the same road.
Mr.
That's
Chairman,
1,000 feet away, whatever it is.
Yes, go-
The
is that
problem
you,
is,
Tom?
we're getting off
Just
track
so I
here.
can kill these people.
that's my point, Mr. Chairman.
Yep.
She never was gonna move from day one.
The review,
I just texted my lawyer. You need to explain to these people.
so.
If she was going to move from day one, then why did the attorneys agree to this?
So
Hey, Tom, I have a question for you, okay?
can I just make a standing objection to new testimony not on the record being made by the appellant or anyone else? This is not the time nor place for new testimony that's not in the evidentiary record from the planning board. And so I just want to make that statement. I'll be happy to answer your question, Mr. McPhillips.
Okay, thank you. This is kind of piggybacking on Peter's question. In September,
Yes,
when it went before the planning board, right? I'm sure they had to have master plan of what they wanted to do, right?
yes,
How many units they wanted to build and how they wanted to have an egress or an ingress. So was the egress and ingress going to go through Cohasset Avenue or was it going to be a cul-de-sac?
cul-de-sac coming out on Carlson Circle.
That was the initial plan as
Yes.
it was going to come as a cul-de-sac
Yes,
in September.
right.
The planning board, so the original plans, which we never saw. This is kind of secondhand coming before us. We're kind of putting the cart before the horse, you know what I mean? We're kind of getting it after the fact, ex facto. We weren't in any of the meetings. So
Sure,
the
so
original
that-
plan in September was a cul-de-sac.
That was the plan. Yeah, that was the plan presented and approved for master plan
In September.
in September.
Okay, then it comes back in November. That's when they had the situation where they wanted to go out to the Cohasset Avenue.
Right. Even the stipulation was only to investigate whether it would be possible, kind of thing. It wasn't even a stipulation from the planning board directing an entranceway from Queeset.
The stipulation was a stipulation for the applicant to request of DOT the possibility of entering the property through Cohasset Avenue.
Okay,
It was not an order
okay,
to go to Cohasset Avenue. It was in order to find out whether or not DOT would allow an access to Cohasset Avenue. That's what's being appealed.
and initially DOT said it was okay.
No,
DOT did
DOT,
not make any-
DOT said not, DOT said no.
they never went to DOT.
Never went to
They're,
DOT.
they're, what the appeal
never-
tonight is, the
It
planning.
never even got submitted.
Okay,
That's right, what Mr. Tyler has appealed is that after they agreed to say that they would ask DOT whether they could go to Cohasset Avenue, they then came back and said, look, there's no sense in making us ask DOT because we can't get there. The planning board said, okay, you don't have to ask DOT. That's what Mr. Tyler is complaining about.
okay.
Yes. In so many words, yeah.
Great.
Anybody have else any questions, commentaries, anything else? Like I said, this is an unusual one. We don't usually get these once every 2 or 3 years.
I have a list of 4 people right now that are wanting to speak.
If,
I object, Mr. McPhillips.
well, okay,
Well, they have the right to speak.
hold on a second, Tom. What's your name, sir? Who's the host?
My name's Lieutenant John Batello from the fire department.
Okay, John. If all 4 of them have the same line of commentary, just have like 1 or 2 people do it.
I don't know what
Mike,
I don't know what they have to
What's
say. They just have their hands raised in
Mike,
the,
every one of them has the right to speak.
Okay, all right.
okay, so I'm going to unmute and allow to speak. His name is Jeff Roussel. He's in the gallery now.
Hello, can you hear me?
Yeah, Jeff, your name and address, Jeff?
Jeffrey Roussel, 41 Sweetbriar Lane, West Warwick. I was at the meeting, the
Yeah,
community
wait a minute,
meeting
Jeff.
that
Jeff,
Chris spoke
I'm gonna
about
ask you-
a few weeks ago,
Jeff, hold on.
and the
gonna
residents
ask you-
were airing
Jeff,
their concerns about
Jeff,
this proposal.
Could you raise your right hand? Swear to tell the
can.
truth, the whole
I'm
truth,
sorry?
nothing but the truth.
Oh, yes.
Thank you.
I
Go
was,
ahead.
as I said earlier, I was at the community meeting that Chris spoke about. And there were some concerns, obviously, about the entrance and exit of this proposed development. One of my questions is the master plan that was approved in September. What did that plan look like? Was there an entrance and egress onto Cohasset, or was it proposed onto Carlson Circle?
Carlson Circle.
So the planning board put a stipulation that the development would be better served, or the community would be better served if it went onto Cohasset Avenue.
No,
Not at that time.
the planning board put a stipulation that the applicant request of DOT
Okay,
whether or not DOT would allow access to Cohasset Avenue.
so the June Car property, what was the initial proposed use of that lot?
As is.
As is, it was gonna be sold as is, it was gonna be,
It was going to be part of the development with the house on it.
okay. So with that house in its present location, there was no way for a road to be put in between the 2 homes going onto Cohasset Avenue.
Correct.
Okay, so if this stipulation is removed this evening, what's the next process in this development?
If the stipulation is removed, the matter goes back to the planning board for the removal from the decision.
To get the stipulation out?
No, the stipulation goes back in.
Right now, the stipulation is out.
Yes. If the zoning boards, basically, to put it in simplest term, the zoning board tonight will either decide the stipulation remains out Well, the stipulation goes back in, and then it goes back to the planning board to start at that point in time
So
and do
I'm
the
sorry.
stipulation.
So are there more, would there be more public hearings at that point
Yes,
to debate the proposed development?
yes,
At that point, the residents can then object to the width of the road, where it's dumping into, water pressure, sewer issues, groundwater, all of those types of things.
the residents are gonna have that come before them in any, whether this is removed or not, because it is there on master plan. It goes back to the planning board for what is called preliminary approval. And at that point in time, all things like drainage and all the absolute detail is presented to the planning board for its preliminary and final approval. So this whole matter goes back to planning.
Would that include a review of this again for the road going in and out when it went back? Or would this be a moot point at that point in
Oh, the
time?
planning board can raise that issue again.
So they would have the opportunity to discuss the access of this at, I'm sorry, I don't remember what I didn't know the word you used, final
Preliminary.
approval, preliminary. And there's public hearing for that, and they have the
Yes.
ability to speak to this same issue at that point in time.
Yes, however, you've got, you're speaking to a planning board that has once rendered a decision, and they would be basically asking for the same thing they're asking you.
So Mr. Kelsey raised a good point about perhaps this becoming open space or some other avenue could be reached. Is Mr., I see the attorney for June Carr is in attendance. Has there been a price put on that piece of property that could possibly be negotiated for open space?
Although I represent the applicant, Mr. Roussel, I can only report anecdotally that June Carr approached the town of West Warwick prior to selling it to my clients for this development in order for them to preserve it as recreational space. What those negotiations look like, I'm not privy to, but her first proposal was to the town of West Warwick to preserve the land. Obviously, no agreement was reached.
Well, I also have to say that the time frame that, as Mr. Roussel, as you are aware, there's a whole process before the town can buy property, and that was not offered to the town.
Okay, thank you very much.
All right, I have another person. I have three more, Mr. Chairman. This person is just a call-in user, so you're going to have to ask them their name and address.
Yeah.
And this is, and I just activated them.
Hello? Hello? He's on mute. Hello?
Hello.
Yes, could you state your name and address, please?
Yes, my name is Jason Licciardi, 26 Carlson Circle.
Jason, could you raise your right hand and swear to tell the truth, whole truth, and nothing but the truth?
Yes. Oh, I swear to tell the truth and nothing but the truth.
Okay,
For the record, I am the town councilman for this ward, Ward 4. I am speaking tonight as an abutter to this property, as a neighbor to Chris Tyler. And to disclose everything, I did file, write a letter to the Ethics Commission, and I received a written letter from them regarding their decision of how I can speak and what I can say.
Mr. Licciardi, for purposes of the record, I would suggest that not to create any problems for anyone, that you read that content into that letter into the record, so that if there are any objectors to your participating, you've got the ethics letter on record.
Attorney, I'm not at my house actually,
Okay,
and the letter is in my house.
Well,
but I'm very clear what I can say, and how I can say it, and I plan on making a copy for you, so you have that.
all right, I would ask that copy, I'll discuss it with Rachel when the letter comes in as to what number, but I would ask the board that I will get the copy and make it part of the official record. Okay, Jason?
Okay, that's fine.
All right,
Can I speak?
yes.
Okay, I'm not going to rehash everything. I was at all three meetings, as a neighbor, as a constituent, and I'll try to keep on topic here. At the September meeting, I understood as a neighbor who's going to be facing this entrance and exit, and the lights are going to be going directly into my home. I have an issue with this, and I'm not trying to obstruct the development. If they want to put 7 houses here, 17 houses, I don't care. It's really the seller wants to sell and a buyer wants to buy. I understand that. However, when I left the September meeting, I understood that there were 8 lots on this big piece of property. One is already existing. What was asked was to go to DOT to see if a road could be put out to Cohasset Avenue, because this whole development was part of this, all 8 lots. So I left the meeting thinking, okay, we're going to find out yes or no if that can happen. If it's no, it's no. This is back 11 months ago. So after September, you hear nothing. I have a map in front of me supplied by the town planner, which he sent to all the butters. I'm going by that map. I go to the January meeting, and yes, we were allowed to speak again. And I have asked several questions as a neighbor, as a father whose child has autism and is going to get every light going into his room. And believe me, I am going to fight this as a father, because my kid can't speak for himself. So January comes, I'm asking questions. All of a sudden, I'm asking questions about the map, the master plan that had already been approved in September. One planning board member could answer the question. Another planning board member couldn't, because his map that he had was different. So then I asked, how many maps are there? What was approved and what wasn't? Again, questions not answered. So we speak at the January meeting. We leave with a continuation. February, myself, Mr. Tyler, along with many other neighbors, went to that meeting. Now, in my neighborhood, and this does make a difference, there are a lot of elderly people here. They wouldn't know what a Zoom is. Never mind trying to get on by cell phone. Look at the problems we're all having now. And they're saying to us, they're asking me as their neighbor, what do I do? How come I can't be heard? This isn't fair to me. And I realize with COVID that we have to do this on the phone. Again, I don't have an answer for them, but they have concerns as well, because everything's going to be affecting us. We are 50 feet away from going out to the main road. If you can't do it, you can't do it. However, we don't even know that. So then come the February meeting, it was about 3 minutes long. An affidavit was introduced. What that said, I have no idea. I'd like to know what it said. When I left the February meeting, I'm the one that asked the question, can we speak? Can we talk? And the answer was no. So I have no idea what was on that affidavit. It could have been one statement. It could have been 10. It could have been a grocery list for all I know. And that's not right. That's not full transparency. And as an abutter to this property who has several concerns, I have the right to know that. And that was wrong. And if you can tell me that's transparent, then we have another problem. And for the record, Mr. Cronin was not at the September meeting. John Brunero was the attorney present. And he's the one that made the decision to say, yes, we will go and ask the DOT. Just for the record. As far as open space goes, I mean, that's not my call. It's great to look at. Now, we're not looking at a field here. This isn't a baseball field we're looking at. I'm outside right now. and I'm looking at somebody's backyard from my front yard. So let's clarify what this is. And I don't know when I'm going to be looking at driveways, at the back of houses, or I'm going to be looking at lights right now of everybody coming out of that development, which is going to be 7 houses, roughly say 2 cars, maybe 2.5, say 20 cars coming out anytime right now when it's dark and the lights are going just like a disco right into my house. Tell me that's a way to live. No, I have a child with autism and the lights are going to be going around his room. Just because what? Because somebody doesn't want to take the extra step to see if a road can go a different way. And there's going to be a host of other issues here, which that's not for tonight's meeting. But the whole thing doesn't make sense. So that's really all I have.
So,
Anybody else?
Yes, Mr. DeFiore, I have Chris Sheehan. I'm going to activate right now. I just did.
Hello, Chris.
Good evening, Chris Sheehan,
Could you spell your last name, please?
Sheehan.
And your address?
Yes, sir. 67 Ross Hill Road, Charlestown, Rhode Island.
One moment, Chris.
Yes, sir.
Could you raise your right hand? Swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay.
On May 21st, 2018, I represent June Carr and met with Jason and the town planner, Mark Carullo, at the property in question. And I represent Ms. Carr as her agent, and it was asked to see if the town wanted to purchase the property. Had a very good conversation with Jason and Mark Carullo. And they said, yeah, we would be interested. Later that summer, I sent an email to Mr. Carullo, could the family receive an intent to purchase the property? They couldn't do so because of the process that it takes to purchase land in the town of West Warwick. Jason called me, said that, it's an election year. A couple of the members of the council weren't sure they were going to get reelected and didn't want to present it.
I'm going to ask Mr. Sheehan, I'm going to ask you not to get into that. If you want to talk about the process.
Yep.
Once an
I'm only mentioning
offer is
this.
made, it has to go to the public at a financial town meeting.
Yep, that's right. You had mentioned that you weren't sure why the town didn't purchase the property, and I just wanted to let you know.
I didn't mention that. Mr. Cronin did.
So I think what Jason and others, the neighbors are talking about was a road coming out onto Cohasset Avenue was because they didn't want the road going out to Carlson Circle. And Miss Carr, she lives there. She's 93 years old, lived there her whole life since 6 years old when Cohasset Avenue was a dirt road.
Mr. Sheehan, if you're going to tell us what Miss Carr wants or doesn't want, I can't allow that. That's
okay, fine. Well, Mr. Licardi asked about the affidavit. The purpose of the affidavit was that she lives in the house and she's going to continue to live in the house. That was the only purpose of the affidavit. And that's always been her intention.
That's as far as I want to let you go with that.
Okay. But I just want to, I guess then I have nothing more to say other than, we've been working on this since 2018 and, that's all I have to say. Thank you, sir.
Mr. DeFiore, I have one last person, Karen. I'm going to let her speak now.
Karen?
Hi, Karen Wisney.
Karen, can you spell your last name?
Wisne.
And your address?
41 Carlson Circle.
Would you raise your right hand?
Yes,
Swear to tell the truth, the whole truth, and nothing but the truth?
yes.
Go ahead.
I'm one of the neighbors here with Chris and Jason, and I wanted to show my support. They were correct in everything they've said. I was at the January and the February meeting. I think what Chris was trying to explain was that there are a lot of angry, upset neighbors about what was going on. We feel there's maybe a little bait and switch or something, that decisions have already been made that we're not getting to talk to. At the January meeting, it was adjourned and we didn't know we wouldn't be able to speak at the February meeting. So when we got to the February meeting, and we were just totally shut down, and it was upsetting as neighbors. But as Jason said, you know, we were only looking for that stipulation to ask if a road could be put in, and a lot of people are assuming that it can't. So we don't see the harm in asking DOT, you know, what's their opinion. You know, as for Carlson Circle, a lot of neighbors have owned these properties for 70 years and more. So we are as invested as anybody in this neighborhood. And that's really what I wanted to say. That I agree with everything Chris and Jason have put forth to you. Thank you.
John, if there's nobody else that wants to speak.
No, there's nobody else that wants to speak.
Okay.
There's nobody else's hand is raised.
Okay. I would say that if Mr. Cronin wants to make a closing statement, after that, a motion to close the public hearing.
Mr. Chairman, I would like to make a brief closing statement. Can the board hear me okay?
Yes.
Yes.
Thanks. So this is an appeal. The way I read the appeal is that the neighbors were not given an opportunity to speak at the February 2020 hearing. And so that's a procedural item that the public hearing was closed in January of 2020. Lots of other things have been discussed here, and I guess I didn't really plan on discussing the project, but it seems like it'd be helpful at this time, given.
I don't know. If you want to speak to that, what you've already said, that's fine, but not getting into the project, Tom.
Okay. Well, there's been so many statements that are just wrong, you know, so I don't know how to correct them other than to deliver the facts from the record. But so this would be the simple way to do it then. I'll point you to the record. In September of 2019, master plan was granted for this 8-lot subdivision. In that master plan, the entrance egress to that project was from Carlson Circle on a cul-de-sac. They did include this stipulation to check with DOT. And when I introduced this matter, I had said that my partner, John Bernero, maybe didn't check the plans carefully enough when he said that he would consider that, but because Ms. Carr's house is in the middle of that lot facing Queeset Avenue, and it's not possible. As soon as we found that out, we made an application to the planning board in November. Was heard in January. We made a presentation. There was public comment. Mr. Sheehan, who you heard from today, was present at that meeting and spoke on behalf of Ms. Carr. The planning board, being careful, didn't want to take his word for it and requested an affidavit from her as to her ownership and her intentions to stay. That affidavit was delivered in February, in the February 2020 meeting. I was not allowed to speak at that meeting. No one was allowed to speak at that meeting because the public hearing had been closed. The planning board considered the affidavit and made their decision based on the record from January 2020 in the affidavit. The fact that the neighbors were not allowed to speak at the February meeting is as a result of the public hearing being closed, not as a result of any procedural error or mistake on the part of the planning board. So that's just to point you to the pertinent parts of the record. I hope I stayed within your bounds, Mr. DeFiore.
Mike, I would suggest at this point in time, a motion to close the public hearing, and then I will give an instruction to the board as to their function.
Okay, making motion to close the public hearing. Do I hear a second? I'll make the motion on it. Is there a second?
I'll second.
Okay, all in favor?
Aye.
Aye.
Okay, all right, Al, give us the instruction. Like I said,
Okay.
we don't generally see these every couple of years.
The instruction you have is that what is before you tonight in its simplest form is a request that this board say to the planning board, put the restriction, put the stipulation that they must ask the DOT whether or not access can be granted through to Cohasset Avenue. If you vote to do that, the matter then goes back to the planning board. The stipulation goes back in place, and the request has to be made to DOT as to whether or not they will allow access to Cohasset Avenue. If DOT says yes, they will allow it, then it will go on to the planning board in preliminary as to whether or not the planning board will say to them, we want access. You're sending it back to the planning board tonight does not in any way say, planning board, we want you to grant access to Cohasset Avenue. What you will be saying is either Shoreline, you don't have to go to DOT, or Shoreline, you do have to go make a request to DOT. That's in a nutshell what you will be doing tonight.
Okay, but our purview on this is pretty narrow. Because
Yes,
if
extremely narrow.
if I'm reading this correctly, it says the Board of Appeals shall not reverse the decision of the planning board or administrative officer except on a basically you got three findings.
Yes.
Prejudicial procedure error, clear error, or lack of support by the weight of the evidence, right? Those are the three. We would have to say yes to one of those three.
Yes,
Send it back.
for example, if you said, and I will just give this, that you felt that what was presented to the planning board was not sufficient for them to remove the stipulation, that would be a reason.
But not having seen that evidence, that's kind of a tough call to make, I would say.
Well, that's
From our standpoint.
you have Mr. Tyler, and I accept the fact that he's not an attorney and the details of it. It would have been his obligation to present anything of that nature that he wanted to you. So basically, it's your decision is, do you want them to go to DOT and ask if they can put a road in or not? That's as simple as I can make it.
Except there's a document saying that the lady does not gonna accept it. Let me make sure I get the question straight.
But that becomes a question for the planning board. on
Okay, that's not for
preliminary.
us then.
No,
That's not for us, okay.
no. All your only function is whether or not they have to say to DOT, will you allow access to Cohasset Avenue? That's your sole function.
Okay, guys, discussion?
Mr. Chairman,
Yeah, fire away, Pete.
All ready to go.
Say again?
I said, I'm ready to go if that's the case. We can debate this until we turn blue.
That's for sure.
But the fact of the matter is, there's items in the overall view of this building plat development that are not variable. They're very narrow in the things that they can and they cannot do. As a board, we cannot make a ruling on a possible future development. That's not in our purview either. But in the meantime, wouldn't it be great if they could get access for an opening to Cohasset Avenue with a curb cut? But the fact of the matter is, the owner of the project deems that she is not selling. The applicant of the project, the applicant rather of the item in front of us, does not own the property. If Mr. Tyler owned the property, it would be different. If his neighbors got together and owned the property, it would be different, but that is not what's in front of us.
Mhm.
Unfortunately, I think we only have one option here, and I'll be voting no, which will be to uphold the West Warwick Planning Board's decision.
I think our purview is pretty narrow too, Peter. I happen to agree with that. I can't see how any of the three items that we have to go
And
by,
that-
they made an
and that-
error on.
And that
As much
doesn't
as I can feel for the people who live over in that neighborhood.
and that doesn't mean that that couldn't happen in the future, but it's nothing for us to determine today. It might be developed that maybe the house next to the car property will be opened up. I don't know. That's, again, it's all speculation,
Yep.
which is the type of format that the planning board has given the contractor. It's in speculation. It's not a preliminary and it's not a final approval.
Right. It's
It's
all
a-
preliminary.
it's a
And Peter, to
preliminary-
your point, Peter, that's what I was trying to say earlier, is that if this is going to go to preliminary, they'll still have an opportunity to speak to this, and that's not up to us.
Right.
That's not.
We can't do anything. The only thing that we can say is kind of the obvious. I would love to say that there'd be a future opportunity that would have a second egress out of that plat. I'd love to say, and I know where Jason lives, I would say that the planner or the architect in that plat should be able to deviate a road going on an angle slightly away from his house. Those all are fairly simple, easy things to do. But we don't have that opportunity now. So I'll be voting no, which will be to uphold the West Warwick Planning Board's decision.
Anybody else? I mean, I feel the same way Peter does. I mean, they really didn't make there wasn't any kind of egregious error. So I have to, like I say, we're pretty tight in our purview on this one. We don't have too much leeway.
I would suggest that then, that the motion be to deny the appeal.
Okay. I think we should make a motion that we actually deny the appeal. You have a second?
Second.
Oh, second.
Okay. Is that a roll call?
Yes.
It should be.
You're on, Rachel.
Do we need a full motion?
Mike made the motion to deny the appeal.
Okay. And
Go ahead,
now,
Rachel.
can I just ask a clarifying question? So
Yeah.
the motion to deny, a yes vote
A
supports.
yes
deny.
vote says that the appeal fails.
Okay,
No,
because
Al, is that right?
Yeah, you're making a motion to deny the appeal.
Yeah,
If you
sorry.
deny it.
You agree with
it
the
fails.
motion, you would
It's
say
it's a
yes.
double negative, but yeah.
Yeah,
Peter Kelsey,
yes.
Yes, I move to deny the appeal.
Alan Horak,
The same as Peter, yes, I will move to deny the appeal. For
Justin
the same
Kuchar.
reason, just
Oh.
if I could add, just for the same reasons, the findings of fact that were presented tonight really do not support any of the three findings that would allow us to overturn this.
Justin Kuchar,
I'm gonna also vote to deny, so I'm a yes, for all the same reasons as Mike, Alan, Peter, and Richard all discussed.
Thanks.
I'll be voting yes to deny, based on the fact that there's no procedural error and the other comments made by our other board members.
Michael McPhillips,
Yes, I'll be voting to deny also for the reasons I've already stated.
Motion. the
Motion
appeal
is denied. Motion for the appeal is denied.
The appeal itself is denied.
The appeal itself is denied.
Thank you for the board's time.
Okay, got a motion to adjourn?
Make a motion to adjourn.
Second,
Second. Have a good one, everybody. We'll see you guys next month.
thank you.
Yeah.